How do you set up an estate plan if you don't have a lot of money? This is estate planning lawyer Michael Pevney, and I create estate plans for families in California. So every once in a while, I'll get the question on different social media platforms, well, I don't really have a lot of money, but I do want to set up an estate plan, and sometimes you are able to do it yourself. Typically, I don't recommend that, especially if you are one, a homeowner, and two, own or rather have kids that are under the age of about 25 or 30. With that, I typically would recommend using a revocable living trust, and that's usually best set up by a lawyer. But if you don't own a home, you don't have a lot of money, you can do this on your own for free. And there are a lot of resources out there specifically that might even be set up by the state that are sort of state forms that you can fill out and either get witnessed or notarized. The important thing to remember if you decide to go it alone is that you are not going to be working with any legal advice from an attorney, and you have to make sure that you follow through, meaning actually get the documents executed. When I say executed, I mean signed and either notarized or witnessed, whatever your state's law is. So I practice in California. I do know a bit about this. So step one to doing your own estate planning is updating beneficiaries on all of your accounts. What we really want to avoid is probate. So probate is the government-controlled and court-supervised asset distribution program. And we can avoid probate by putting any accounts that we have, checking, savings, investments, 401k, IRA, and life insurance by naming a beneficiary, and also naming an alternate beneficiary in case that beneficiary passes away before we do. So we always want to name and update those beneficiaries. When you pass away, those beneficiaries will get that money from that account automatically to them without it having to go through the courts or the probate process. So that's step one, getting everything proper beneficiary notification on all of those accounts. Step number two is getting healthcare documents in order. In California, that is a single document called an Advance Healthcare Directive. And in that form, you make decisions. So first, you kind of make a big decision whether it's you want to choose to prolong your life or not, if you are in a coma or you're incapacitated. And that's kind of like, pulling the plug, basically. Do you want to do that? Do you want to donate your organs? And then who do you want making healthcare decisions on your behalf? You can set a primary person, an alternate, and even a second alternate if you want. And those documents are available, pre-printed forms are available on, at least in California, on the California state website. It is absolutely essential, though, that those documents be either witnessed or notarized, that the person that you want in charge or that you want making those decisions for you has access to them. Because unless the hospital knows that you have this document, nobody's going to know. The third document you want to have set up is a power of attorney, a durable power of attorney. That's different than a healthcare power of attorney. This is a financial power of attorney. So this is the person that can make financial decisions for you, that can do banking for you. You get to choose whether or not you want that to take effect immediately. You get to choose whether or not you want that to be durable, meaning it remains in effect after you are incapacitated. That's important for sometimes elderly people, sometimes people that might be facing dementia in the future, and it can just be a convenience to some people to not have to handle their banking on their own. Again, very important that these documents are signed and or notarized, and that the important people, the people that you are nominating to be your power of attorney, have access to them. Because if these forms can't be found, whatever your intent was is not going to be followed through with. The people that are making those decisions are not going to be able to make those decisions because they can't show these documents to the bank. And banks can get a little bit tricky about the types of documents that they're going to accept. So we want to make sure that they are executed properly, meaning signed and or notarized. And then the last thing that you need to make sure that you have is a will, a very simple will. Now, depending on the size of your assets, a will might still have to go through probate, especially if you have significant assets and there aren't live beneficiaries that are designated on all of your accounts. So this will, you can get a pre-printed statutory will from the state of California court's website that basically gives you the choice of who you want your property to go to, who you want specific amounts to go to, and then the rest of things in percentages. And if you have kids under the age of 18, you can actually nominate a guardian in this document. And a will, in California at least, is not notarized, but it must be witnessed by 2 people when you sign the will. So that's an important thing to do. Now, all 4 of these things that I'm talking about, you can do on your own. Designating the beneficiaries, you've got to go through your own financial institution, and then the 3 other documents, the Advance Healthcare Directive, the Financial Power of Attorney, and the will, are all available in free pre-printed forms. Now, what you are not getting, remember, is legal advice, right? You're not talking to a lawyer, you don't have access to a lawyer, you haven't hired a lawyer to help you and give you advice in how to execute these documents. But if you really don't have a lot of money, or maybe you're kind of cheap and really don't want to do this stuff, that's something that you can do. Now, when it comes to people that are homeowners, and where I live, the probate process for getting a home through probate can easily cost $50,000 or more for people like that, or maybe you have kids that aren't super responsible, that are under maybe 30 and certainly under 18. I typically recommend a trust, a revocable living trust, and I really would never recommend that somebody write their own trust. Best to get the help of a lawyer. But if somebody's very young, they haven't built up a lot of assets, maybe they're not married yet, they don't have any kids, they're renting, and you can just designate those beneficiaries. This can be done on the cheap, and there are resources out there for it to be done. But if it is time to look at getting a professional estate plan done with a professional attorney, you can contact me for free to set up a free estate planning strategy session at ocestateplanlawyer.com. Go ahead and like this video if you got some value out of it, and subscribe if you'd like to hear any more information. Thanks for watching.